Double jeopardy is an interesting area that mitigates the entire space of adjudication. Double jeopardy is interesting, one, because it's a compound word. Like we have always said here, that one of the ways that will help you appreciate a word and the operation of that word is to appreciate how that word is structured. Whether you're a lawyer, a medical practitioner, an engineer, an accountant, whatever you're doing, as long as you live on the instrumentation of words, it's very important that we constantly try to understand how words come together, etymology of words, and what words convey on their face value. You will be shocked how sometimes you can take a word to mean what you think it means, but that word, by the way it is constructed, the instrumentation and application of that word is very different. So double jeopardy is a compound word made of double and jeopardy. So double means the intensity happens more than once, and jeopardy means to place at risk or to torment. So double jeopardy, if we bring them together in adjudication, double jeopardy means that the instance of giving someone pain, tormenting someone, or taking someone through risks for more than one intensity. So that is what it means as double jeopardy. So that is what it would be on its face value. But now let's look at how do we apply double jeopardy. Double jeopardy states that an individual should not be reprimanded. An individual should not be punished more than once for the same offense, being faced with the same type of evidence. So in criminal matters where double jeopardy has taken root, this is whereby when an individual has gone through the adjudication process in a competent court of competent jurisdiction, then at the point whereby the judge exhausts his authority over that matter cannot be retried again. So double jeopardy should not be confused with employing and exhausting the appeal. Double jeopardy means that when a trial is going on, and we have always understood in this class that trial is at the court of first instance. Trials are not subsequent. Trials only happens at the court of first instance. And that is whereby all the cross-examination happens, because subsequently now we are looking at, did that judge when faced with the set of facts, did the judge apply the law appropriately on that set of facts? So that is what happens in appeal. But at the court of first instance, we are looking at the way the evidence and way testimonies are being adduced. That is the court of first instance. Let me mention something in passing briefly. You realize when we were talking about res judicata, and we said that when a court that has competent jurisdiction exhausts its authority over matter, then that matter is finalized. That matter is reached with finality. You remember also when we had said functus officio, though functus officio being the ambit of operation, particularly for people in public service, and we said that functus officio means that when a public official has exhausted his authority in discretion, because the discretional component is the individuality faced with such and such facts. How would you organize and arrange yourself? Because when you're looking at the discretion, we are looking at an individual's choice. We are looking at an individual's performance activities on an individual basis. Two judges faced with the same matter will arrive at two distinct findings. Why? They are discretional. So there are aspects of law that this aspect must be performed on what the law has said, then there are aspects of law that now we give room to the public official to conduct his discretion. And we are saying in functus officio, when a judge or a public official has arrived at a point, that individual has exhausted their discretion on that matter. Similarly, that is how double jeopardy works. That when a court of competent jurisdiction has exhausted its power on a matter at the first instant, the instance of trial, then that court has exhausted its authority on that matter. You remember also we had said that whenever we are talking of the word courts, we are supposed to be aware that courts exist at two levels. The person, the individual sitting in adjudication, that is a court. The judge becomes the court. The magistrate becomes the court. That judge is the court. Secondly, the institution in which that judge sits, so that institution is also a court. So at two levels of court, when a judge, a high court judge sits in high court, it is complete whether that matter is taken to Karatina, whether that matter is taken to Homa Bay, whether that matter is taken to Mombasa or Nairobi. That high court had exhausted its strength. So there is no way you can invent a scenario whereby you can retry a matter. In criminal matters, the reason why we have a very high threshold is because criminal matters deal with withdrawing certain fundamental rights of an individual. Courts are always very hesitant to withdraw an individual's fundamental rights because the courts did not award those fundamental rights to begin with. So that is why the presumption of the presumption of justice, the presumption of innocence is a very sacrosanct, holds a very sacrosanct place in the entire criminal justice system. Double jeopardy moves in to protect an individual from going through torture. There is nothing as torturous as going through a trial. There is nothing that is as risky as going through a trial. The ultimate of the trial, that in itself is also very torturous, but the moment an individual is taken through trial is quite torturous. And courts will always hesitate from putting an individual through torture. In recent times, there's an individual that was called O.J. Simpson. O.J. Simpson was taken through a criminal trial for the murder of his wife. And the courts acquitted O.J. Simpson on fundamental areas. One, the prosecution was using the gloves. So when O.J. tried to put on the gloves, when the gloves did not fit, the court had to acquit. Actually, that was the slogan. If the gloves do not fit, the court must acquit. After being acquitted, that court had exhausted, so the court found this guy to be innocent. Subsequently, the gentleman writes a book, and he wrote a very stupid book. If I did it, Confessions of the Killer. And in the book, it goes painstakingly how that murder would have happened if OJ decided to have committed it. But guess what had kicked in? Another mitigating factor. Statutory time limit. So statutory time limit, and these are things that we need in jurisprudence to understand. What are those points of departure? What are those competing interests? What are those overlapping areas of law that are still gray area? But just to respond to this, it's a very interesting case. If you wanted to read it, the O.J. Simpson case, and even particularly the book is available online. You can access it on PDF. It's an interesting read. But I would want you to understand that double jeopardy helps to protect the person of the accused. We had established that whenever an individual is accused, automatically the courts will side with that individual because of what we had settled by saying that there is an onus, the duty. The duty to accuse an individual shifts that burden on your part that you need to prove beyond any reasonable doubt. If you don't discharge that, courts will rarely give you a second chance. My name is Ogwang, and I hope that I have satisfactorily attended to this question to your liking. And if there might be an area that maybe I overlooked, I would welcome us to interact in the comment section so that we can learn from each other. I am merely a conversation starter. And as a conversation starter, these are just my 2 cents of opinion. And when we interact in an environment of respect, then we can learn a lot. I will see you in the next one. Until then, take care. God bless and bye-bye.